On the night of April 20th, 2010, an explosion tore through the Deepwater Horizon drilling rig in the Gulf of Mexico and set in motion a financial crisis that would ultimately cost one company more than $61 billion. 11 workers were killed, 17 others were injured. The rig, owned by Transocean and leased to BP, burned for 36 hours before it capsized and sank. Most people remember the fire and the oil. Far fewer understand the insurance battles, the liability fights, and the corporate reckonings that followed, and that still shape how the energy industry manages catastrophic risk today. The well was called Macondo. It sat in deep water roughly 40 miles off the Louisiana coast, in water nearly a mile deep, with the reservoir itself lying more than 3 miles beneath the seabed. Halliburton had recently completed a cement job intended to seal the well, so the rig could move on to its next assignment. That evening, the crew was performing a series of pressure tests as part of the temporary abandonment process. The tests did not hold. Hydrocarbons surged up the riser. At approximately 9:45 p.m., the first explosion ripped through the platform. A second blast followed almost immediately. Within minutes, the entire structure was engulfed in flames that could be seen for miles. Survivors evacuated to a nearby supply vessel, the Damon Bankston. Some jumped into the dark water far below. The 11 men who did not make it home left families, colleagues, and an industry suddenly forced to confront the true cost of failure in deep water. For 87 days, the well continued to discharge oil into the Gulf. Engineers tried every method available. They attempted a top kill, pumping heavy drilling mud into the well at high pressure in an effort to overcome the upward flow. They tried junk shots, forcing shredded tires, golf balls, and other debris into the blowout preventer in hopes of clogging it. They lowered containment domes of various designs, only to watch them clog with methane hydrate ice. None of these efforts succeeded. Oil continued to pour into the open ocean day after day. Only when a newly designed capping stack was finally installed and closed on July 15th did the flow stop. A relief well drilled from a second rig permanently sealed the Macondo well weeks later. Government scientists on the flow rate technical group estimated that approximately 4.9 million barrels had been released, the largest offshore oil spill in United States history. The environmental damage was immense. The financial damage would prove even larger. Under the Oil Pollution Act, the operator of an offshore facility bears primary responsibility for removal costs and damages. That responsibility fell squarely on BP. The company stated early and repeatedly that it would pay all legitimate claims. What became clear in the months that followed was how little of the ultimate burden would be absorbed by traditional commercial insurance. The Deepwater Horizon itself was insured for $560 million. Transocean carried roughly $950 million in third-party liability coverage. BP, by contrast, relied heavily on its own captive insurer based in Guernsey. Captive insurance is a common tool among large energy companies. It allows them to retain risk inside the corporate family rather than transfer it to the commercial market. Early industry estimates placed total commercial insured losses somewhere between $1 billion and $6 billion. Against the scale of what was coming, those figures represented only a fraction of the total exposure. The great majority of the cost would have to be paid from BP's own balance sheet and from the assets it would later be forced to sell. Almost immediately, the companies began contesting responsibility. BP's internal investigation pointed to failures by the Transocean crew in recognizing the influx of hydrocarbons and to problems with the cement mixture used by Halliburton. Transocean and Halliburton rejected that account. They directed blame back toward BP's decisions on well design, the number of centralizers used to keep the casing centered in the hull, the decision to use a long string production casing rather than a liner, and operational choices made in the final hours before the blowout. The public dispute was intense and prolonged. Anadarko Petroleum, which held a 25% interest in the well, settled with BP in October 2011 by paying $4 billion in cash and transferring its stake in exchange for mutual releases of claims. The settlement removed one major source of uncertainty, but it did not end the larger fight among the remaining parties. Lawsuits flooded the courts. More than 3,000 cases involving over 100,000 named claimants were filed across the country. Fishermen, hotel owners, restaurant operators, property owners, charter boat captains, real estate developers, state governments, and the federal government all sought recovery for economic losses, property damage, and natural resource injuries. Some claims were straightforward, others were complex and contested. BP established the Gulf Coast Claims Facility under the administration of Kenneth Feinberg. That facility alone paid approximately $6.2 billion to more than 220,000 individuals and businesses before it was eventually superseded by a court-supervised settlement program. Even so, the legal pressure continued to intensify. multi-district litigation was consolidated in New Orleans under U.S. District Judge Carl Barbier. The sheer volume of claims and the difficulty of proving causation in many individual cases created years of procedural complexity. In 2012, BP pleaded guilty to criminal charges connected to the disaster and agreed to pay $4 billion in fines and penalties. The plea included 11 felony counts of manslaughter, 1 count of obstruction of Congress, and violations of the Clean Water Act and the Migratory Bird Treaty Act. It was the largest criminal resolution in U.S. history at the time. Then came a decisive legal turning point. In September 2014, after a lengthy non-jury trial, Judge Barbier issued detailed findings of fact and conclusions of law. The court ruled that BP's conduct constituted gross negligence and willful misconduct. Fault was apportioned 67% to BP, 30% to Transocean, and 3% to Halliburton. Transocean and Halliburton were found negligent, but not grossly negligent. The gross negligence finding against BP carried enormous financial consequences. Under the Clean Water Act, the civil penalty per barrel of oil spilled rises dramatically when gross negligence or willful misconduct is established. The difference between ordinary negligence and gross negligence was measured in the tens of billions of dollars. 2 years later, the major civil claims were resolved. In 2016, BP reached a global settlement with the United States and the 5 Gulf states, valued at $20.8 billion, the largest environmental damage settlement in American history. The agreement included a $5.5 billion Clean Water Act civil penalty, up to $8.8 billion for natural resource damages, and several billion more to resolve state and local economic claims. Payments were structured to stretch across 15 to 18 years, so that the financial burden would not overwhelm the company in any single year. When BP announced its final estimate of the pre-tax cost of the entire disaster in July 2016, the number stood at $61.6 billion. That figure encompassed cleanup operations, private claims, government settlements, legal fees, and remaining liabilities. To help meet the obligation, the company sold tens of billions of dollars in assets around the world. Its share price had already collapsed in the immediate aftermath of the spill. Its chief executive, Tony Hayward, had already been replaced. The insurance markets felt the aftershock as well. Rates for offshore drilling coverage rose sharply in the months following the disaster. Some brokers and analysts reported increases of 50% or more for certain deepwater risks. Underwriters began rewriting policy language, tightening joint venture provisions, and reassessing the limits of coverage available for ultra-deepwater operations. Reinsurers re-examined their exposure to aggregation risk, the possibility that a single event could trigger claims across multiple layers of coverage and multiple insured parties at once.
The long-standing assumption that layered insurance, corporate captives, and contractual indemnities could comfortably absorb even a major offshore loss had been tested and found insufficient for an event of this magnitude. The market did not collapse, but it grew more cautious, more expensive, and more demanding of detailed risk information. The disaster forced lasting changes across the industry. Federal regulators rewrote rules governing offshore drilling, well design, and safety systems. The Minerals Management Service was reorganized and eventually split into separate agencies, including the Bureau of Safety and Environmental Enforcement. New requirements were imposed for blowout preventers, well control equipment, and real-time monitoring. Companies that once treated insurance primarily as a routine cost of doing business began treating it as a core element of strategic risk management. The architecture of liability that surrounds energy production in deep water was permanently altered. Premiums, policy wording, contractual indemnities, and corporate self-insurance practices all shifted in response to what had been revealed. Boards of directors and risk committees paid closer attention to worst-case scenarios that had previously seemed remote. 11 workers never came home from the Deepwater Horizon. The Gulf of Mexico absorbed nearly 5 million barrels of oil. Coastal communities suffered economic losses that lasted for years, and the financial system that was supposed to distribute the consequences of such a catastrophe revealed both its capacity and its limits. The explosion on April 20th, 2010, did not simply generate large insurance claims. It exposed how fragile the arrangements for sharing catastrophic risk had become when multiple companies, multiple layers of coverage, and multiple legal doctrines collided under the pressure of an unprecedented loss. The energy industry its insurers and its regulators emerged with a far more sober understanding of what happens when those arrangements fail, and with new rules designed to prevent the next failure from reaching the same scale.